Imagine creating a breathtaking image without touching a brush, writing a song without playing a single instrument, or publishing an entire book with artificial intelligence doing most of the creative work. Now imagine that creation becomes worth millions of dollars. Who owns it? You, the AI company, or nobody? That question is no longer science fiction. It is becoming one of the biggest battles in modern intellectual property law. Because artificial intelligence has changed something copyright law was built around for centuries. The assumption that a human created the work. Today, we're entering the legal battlefield of AI copyright. We'll look at the United States, the European Union, the United Kingdom, Canada, Australia, and Japan. And by the end, you'll understand one critical rule. Using AI to create something doesn't necessarily mean you own the copyright to it. But the amount of human creativity you add could make all the difference. For centuries, copyright law followed a simple idea. A person creates something original, and the law protects that creation. A painter creates a painting. A writer creates a novel. A musician creates a composition. But artificial intelligence complicates that entire chain. Imagine typing a prompt into an AI image generator. You describe the lighting, the composition, the characters, the atmosphere, and seconds later, an image appears. You didn't paint the pixels. You didn't photograph the scene. You didn't manually draw the character. So here's the uncomfortable question. Did you actually create the image? Or did the machine? And there's another problem. The AI itself isn't a human creator. It doesn't own property. It doesn't sign contracts. It doesn't receive royalties. So we're left with a strange legal gap. A human may have requested the creation. A machine may have generated the result. And the law has to decide whether the final work deserves protection. This creates several major questions. Is the work original? Was there enough human creativity? How much control did the human actually exercise? Can the AI-generated work be commercially exploited? And finally, what happened to the copyrighted material used to train the AI? These questions aren't theoretical. They involve billions of dollars. They affect artists, writers, musicians, software companies, publishers, filmmakers, and AI developers. And governments around the world are taking different approaches, which means your legal rights can change dramatically depending on where you are. Let's start with the United States. The American approach can be summarized in 3 words. Human authorship matters. The U.S. Copyright Office has repeatedly taken the position that copyright protection requires human creativity. One of the most important examples is the case involving Stephen Toller. Toller attempted to register an artwork generated by an AI system. His argument was essentially that the machine should be recognized as the creator. The Copyright Office rejected that position. The broader message was clear. A work created entirely by a machine does not automatically receive copyright protection simply because a human owns or operates the machine. But here's where things get much more interesting. AI doesn't have to be the entire creator. It can also be a tool. Think about a graphic designer. They use AI to generate dozens of possibilities. Then they choose one. They change the composition. They edit the colors. They remove elements. They add typography. They combine the image with human-created artwork. And finally, they produce a finished design. Now there's a much stronger argument for human authorship. The important question becomes, where did the human creativity begin? And where did the machine's contribution end? This distinction became especially visible in the famous Zarya of the Dawn copyright controversy. Christina Castanova created a comic using Midjourney. The Copyright Office ultimately treated the human-created elements differently from the AI-generated images. The text and arrangement could receive protection, but the AI-generated images themselves presented a different problem. And that created an important concept. Hybrid works, part human, part AI, potentially different levels of protection for different components. So imagine two creators. Creator A types one prompt, accepts the first image, and publishes it. Creator B generates 50 versions, selects specific elements, edits the image, combines it with original artwork, and creates a completely new composition. Those two situations may look similar to a viewer. Legally, however, they could be very different. And this brings us to another enormous battle. Training data. AI systems don't appear from nowhere. They are trained using enormous quantities of information. Books, images, articles, music, code, and sometimes copyrighted material. AI companies argue that using this material for training can qualify as fair use. Copyright holders argue that their work shouldn't be copied and commercially exploited without permission. That battle is still unfolding across multiple lawsuits, and the eventual outcome could reshape the economics of artificial intelligence. Now cross the Atlantic, and the philosophy changes. The European Union has generally taken a more human-centered approach to copyright and artificial intelligence. The underlying principle remains familiar. Copyright protects human creativity. But Europe has also focused heavily on what happens before the AI generates anything. Specifically, training data. The EU's copyright framework includes rules concerning text and data mining, while allowing rights holders in certain circumstances to reserve their rights against certain uses. The EU AI Act also introduces transparency obligations for providers of general-purpose AI models, including obligations related to copyright compliance. This creates a very different environment for AI companies. Instead of simply asking, "Can our model generate this?" companies increasingly have to ask, "What data was used to build this model? And did we respect the rights attached to that data?" That distinction could become enormously important, because the future of AI may not be determined only by what an AI produces. It could also depend on what went into training it. Now let's look at the United Kingdom. The UK has an unusual feature in its copyright law. It recognizes a category known as computer-generated works. In certain circumstances, copyright can arise where there is no human author in the traditional sense, with the law focusing on the person who undertook the necessary arrangements for the creation. But here's the problem. The law was written before today's generative AI explosion. So applying those older rules to modern systems creates uncertainty. Imagine a music producer using an AI system to generate hundreds of musical ideas. The producer selects several, rearranges them, edits them, adds human vocals, records instruments, mixes everything together. The final product contains both machine-generated and human-created elements. Where exactly does copyright begin? That's the difficult question. The UK has been consulting on how copyright and AI should interact. And for creators, one practical lesson stands out. Keep evidence of your creative process. Save your prompts. Keep drafts. Keep edited versions. Document what you changed. Because when the legal system asks, How much did you actually create? Your creative process may become evidence. Canada takes another approach. The general principle remains that copyright protects human creativity. But using AI as a tool doesn't automatically eliminate copyright protection. Imagine a designer using AI to generate logo concepts. They create dozens of variations. They select several. They modify the shapes, change the colors, adjust the proportions, combine different elements, and eventually produce a final design. The AI-generated portions may face limitations, but the human-created selection, arrangement, modification, and other original contributions may qualify for protection. This creates an important principle. AI assistance is not necessarily the same thing as AI authorship. And that distinction could become increasingly important as AI becomes embedded in everyday creative software. The question isn't simply, did you use AI? The better question is, what did you actually contribute? Now things get particularly interesting. Let's start with Australia. Australia generally emphasizes human authorship for copyright. AI-generated material by itself may face serious difficulties in receiving copyright protection. But human involvement can change the analysis. Imagine an Australian music producer. They ask AI for 100 beat variations. They choose 10. They manually edit 5. Then they add live instruments. They record vocals. They arrange the track. And finally, they mix and master the entire production. At that point, the finished work contains substantial human creativity. The AI becomes a tool inside a larger creative process. And that distinction is likely to become increasingly important across the creative industries. Now, Japan. Japan has taken a notably innovation-friendly approach to AI development. Japanese copyright law contains exceptions that can allow certain information analysis and machine learning activities involving copyrighted works, subject to the specific legal requirements. But that does not mean every AI-generated output automatically receives copyright. Human creativity remains important when determining whether a generated work qualifies for protection. Japan's philosophy has generally been more permissive toward AI development than some European approaches. And that's a strategic difference. Europe is emphasizing creator rights and transparency. Japan has emphasized technological development. The United States is fighting major battles over fair use. And other countries are still developing their positions. The world is effectively running multiple legal experiments at the same time. So what does all of this mean for you? Suppose you're a YouTuber, a filmmaker, a designer, a musician, a writer, or an entrepreneur using AI to create commercial content. There are several smart steps you can take. First, document your process. Save prompts. Save drafts. Save revisions. Keep original files. Record the changes you make. The goal is simple. If someone questions your authorship, you can demonstrate your human contribution. Second, don't rely entirely on raw AI output. Instead, use AI as part of your creative workflow. Generate ideas. Explore possibilities. Then add your own judgment, your own editing, your own composition, your own storytelling, your own design decisions. Third, understand the terms of the AI platform you're using. Commercial rights, ownership provisions, and restrictions can vary between services and can change over time. Don't assume that generating something automatically means you have unlimited rights. Fourth, Think about jurisdiction. The same work could face different copyright questions in different countries. If your business operates internationally, don't assume one country's rules apply everywhere. And finally, keep your evidence. In the future, proving how a work was created could become just as important as the work itself. Now imagine you're on the other side. You're building an AI model. Your biggest legal risk may not be the output. It may be the training data. Companies increasingly need to think about: where did the data come from? Was it copyrighted? Was permission required? Were rights reservations respected? Can creators opt out? Can the company demonstrate compliance? And can it explain its data practices? The safest strategy is increasingly obvious. Build legal compliance into the AI system from the beginning. That means better data governance, clear documentation, respect for applicable copyright rules, and where appropriate, licensing arrangements. Because the AI industry may eventually move toward a world where high-quality training data becomes something companies explicitly pay for. So where is all of this heading? The next few years could completely reshape the creative economy. First, AI licensing markets could expand. Instead of AI companies simply collecting enormous data sets, creators could increasingly license their work directly. Second, hybrid copyright could become the norm. Not simply human created, not simply AI created, but human created with AI assistance. Third, training data compensation could become a major industry. Imagine a future where creators can license millions of works to AI systems through standardized agreements, similar to how music licensing works today. And fourth, we may see entirely new legal categories. Imagine a copyright system that records human contribution, AI contribution, training data sources, modification history, and ownership rights. In other words, the future of copyright may become partially about provenance. Not just who owns this, but how was this created? So, can you own something AI created? The answer is sometimes, but not simply because you type the prompt. Across many major jurisdictions, purely AI-generated material faces significant barriers to copyright protection. Human creativity remains central, but AI doesn't necessarily destroy copyright. It can become a tool, and the more meaningful human creativity you contribute, the stronger your argument may become. The future probably won't be divided into two simple categories: human versus AI. Instead, we're heading toward a world of human-AI collaboration. Artists using AI, musicians using AI, writers using AI, programmers using AI, filmmakers using AI, and lawyers trying to determine exactly who deserves the rights. The biggest question isn't whether artificial intelligence can create. It clearly can produce things that look, sound, and read remarkably creative. The bigger question is, how much human creativity is enough to turn an AI-assisted creation into a legally protected work? That answer is still being written. And every new court case, every new regulation, and every new AI system could change the rules, because the copyright wars of artificial intelligence aren't ending, they're just beginning.